Hello, NMAR members. I'm Ashley Strauss-Martin, General Counsel for the New Mexico Association of Realtors, and I'm here today to talk to you about some new and revised NMAR forms that we will be adding to the NMAR Forms library in the next couple of weeks. We've got a lot to cover, so let's get started. We've created two new information sheets that we're going to be adding to the library: the Home Inspector Licensing Information Sheet and the Options for Multiple Offers Information Sheet. And we have revised 12 other existing NMAR forms. So as you're all aware, the Home Inspector Licensing law is in full swing now. There was a statute that passed about a little over a year and a half ago, and then there was a Home Inspector Licensing Board that was created from that statute. That Home Inspector Licensing Board then put together a whole lot of regulations, and that has now happened, and all of our home inspectors should be licensed. At the bottom of this slide, you see a licensee lookup link, and you can go to that link to find the most current licensees who have obtained licensure through the New Mexico Home Inspector Licensing Board. So we've created this information sheet to address all of the terms of the statute and also all the regulations that were passed as well. On the first page at the top, you'll see a attention box, and this is similar to our service provider warning that we have in our purchase agreements. And it tells the buyers and sellers that in the event that you as a broker have recommended a home inspector, that they are advised to confirm the home inspector's licensure and to independently investigate and evaluate such person or entity before entering into any contractual arrangements with such person or entity. Towards the back of the information sheet, you'll find an index, and you can tell from the index that this is a very lengthy document. It's 14 pages long, but the index, of course, is there to assist the consumer or you, the broker, in finding a particular topic. And we cover everything that's covered in the statutes as well as everything that was covered in the regulations. And what's interesting about the way that the Home Inspector Licensing Board approached these various elements, roofing, plumbing, electrical, they didn't just cover what the home inspector was required to inspect under these topics. They covered what the home inspector was not expected to investigate under these topics. So that's very helpful for a consumer to see exactly what their inspection is going to cover and exactly what their inspection is not going to cover. We've also included towards the back of the document some information on consumer recourse. So in the event that a consumer has a problem with their home inspector, we have alerted them to the fact that there's a home inspector licensing board and given them that contact information so that they can reach out directly to the board with any kind of concerns. The second new form in our library is an information sheet on options for multiple offers. And we've seen a lot of multiple offer situations in the last 12 to 18 months. This form does a couple of things. It obviously educates, so it educates the seller as to their options in a multiple offer situation. It also lets the buyer know what options the seller has. It also provides evidence that the listing broker has gone over those options. Sometimes when a buyer doesn't win a bid, they are under the impression that something went wrong on the listing side and that perhaps the seller wasn't made aware of those options, especially if the winning bid is a buyer who is also represented by the listing broker. So if the listing broker uses this form, has the seller sign off on it, it provides evidence that the seller was made aware of their options and made the choice that they wish to make. Option number one is accept one offer. So if seller is satisfied with all of the stated terms in one of the offers submitted, then the seller may accept that offer as it's presented anytime up until the expiration date or the revocation of that offer. And they do this by initialing all pages of the purchase offer and selecting and signing in the acceptance section on page 17, and then delivering the fully executed purchase agreement to the buyer whose offer was accepted. And then once fully executed, of course, and delivered, you have a legally binding contract. And then it talks about what you do with the other offers that were not accepted. And the seller should notify the remaining buyers that their offers have been rejected by selecting the rejection section on page 17. It is not necessary for the seller to initial each of the pages in the event they're rejecting, but once they complete that rejection box on page 17, they need to deliver that back to the buyers, each individual buyer whose offer was rejected. Option number two is submit a counteroffer, and there's a box at the top that gives the seller some important things to think about. First of all, it says when choosing this option to counter, the buyer may only respond to one offer or run the risk of contracting with two or more parties. So Of course, if you send out multiple counteroffers and those buyers accept those counteroffers, then the seller could be under contract with more than one buyer, but there's only one property. So that's problematic. So you're only going to counter one offer at a time. The second bullet says that submission of a counteroffer is a rejection of the original offer, and the seller may not be able to accept the original offer once a counteroffer has been submitted unless agreed to by the buyer. This is quite frequently misunderstood, where parties will submit a counteroffer, and when the party to whom it was submitted doesn't wish to accept those terms, then the party who submitted the counteroffer wants to go back to the original offer and wants to accept those terms from the original offer. But you have to remember that when a counteroffer is submitted, it is a rejection of all those terms, and you can't go back and accept that original offer unless the party who put that on the table initially says it's open again, it's back on the table. So you may lose the opportunity to accept the terms of the original offer anytime you counteroffer. And lastly, if the seller chooses to revoke a counteroffer, this must be done before the buyer accepts the counteroffer. Once it's accepted and delivered, then you have a contract. So you have to pull it back off the table before that happens. We reference Form 5106, which is our revocation of offer counteroffer form, and we suggest that that form be used. And the reason we suggest that form be used is because it's very common for brokers to revoke offers. Brokers are typically working as transaction brokers and not agents. So as a transaction broker, you don't have the ability to bind your client with words and actions. And that seems to be very clear that as a transaction broker, you're not accepting or rejecting or even countering an offer. But when it comes to revocation, it's quite frequent that the transaction broker is doing the revocation, him or herself. So we advise that the revocation actually come from the party to the contract or to the transaction that is doing the revocation. And that's what 5106 does. It has, in this scenario, it would have the seller signing off that they're revoking their counteroffer to the buyer. It's not always feasible for you to get the signatures of your clients on a 5106. And you have to remember that time is of the essence when you're revoking, because as soon as it's accepted, delivered, you've got a contract. And so you're trying to revoke it before that occurs. And so it might not be practical to get a 5106 signed by your client. In that case, there's some other scenarios. You could have the seller send you an email saying they're revoking, which you can then forward over to the other side. So again, the revocation is coming from the seller directly through you, but it's still a seller email. The third case scenario is where, for whatever reason, the seller can't sign 5106, can't send you an email, and you as the broker are having to send the email. So send the email. That's what you've been directed to do, and that's the only thing that can be done given the time constraints. Then send the email, and how that will play out, we'll see. Sometimes even more removed than that, you can't send an email and you end up having to pick up the phone and orally revoke. But of course, anytime you're doing anything not in writing, you run the risk of challenge because it's not in writing and there's no proof that it occurred. So in that scenario, if that's the only thing you can do, then yes, pick up the phone and revoke the offer orally. And again, we'll see how that plays out. So in the event that they are countering, then it tells them how to do that. It tells them that they will initial each of the pages, that they will check the counteroffer section of page 17, and they will initial down there in the corner of that box. And then it goes on to tell them what they will do and with all the other offers that they received. Some of them, they might know right off the bat that they want to revoke those offers. Reject those offers. And so they would just check the rejection section on page 17 and initial down there in the box and send it back over to the buyer who submitted that offer. However, it gives us a couple of things for the seller to think about. In the event that the seller has countered one of the offers and they're waiting to see if that deal is going to come to fruition, whether or not that buyer is going to accept that counter offer, and they've got other offers on the table that may have expiration dates that are somewhere into the future. They haven't expired yet. They're still on the table. The seller may wish to see if that first transaction with that first buyer to whom they've submitted the counteroffer will actually happen, will actually come together, and the buyer will accept that counteroffer. They may wish to see if that happens before they reject those other offers that have expiration dates well into the future. So when they're rejecting, they only want to reject those offers that they know that I don't want to accept this now, I'm not going to want to accept this in the future, so they can go ahead and reject it. If they think they may wish to entertain that offer or maybe counter that offer at some time in the future, and the expiration date is set out and allows them some time to consider it, then they could see how the first deal with that first buyer to whom they submitted the counteroffer, how that played out. And if it didn't, then they could go back and accept one of those other offers where the expiration date hadn't yet expired, or they could counter one of those offers. So they may wish to wait to reject until they see how that first deal plays out. Option 3 is the notice of multiple offers, and it references NMAR Form 5103. And it says that if the seller does not wish to accept or counter any of the offers received, but instead wishes to give each buyer the opportunity to submit a new offer with their highest and best terms, or with specific terms that are important to the seller, then the seller will notify the buyers by selecting and initialing the notification of multiple offer section on page 17 and submitting to those buyers NMAR Form 5103, which is the notification of multiple offers. In this scenario, it is not necessary for the seller to initial each page of the offers that they have received. In the notification, there is a date, and it says that the seller will not be entertaining offers after a certain date. But you have to remember that that does not stop the seller from accepting any new or existing offer prior to that deadline. So we saw a lot of this in the MLS over the last 12 to 18 months. There'd be a date in there that said that the seller was going to review all offers at, let's say, 5 o'clock on Tuesday, and then a buyer would find out that at noon on Monday, the seller accepted an offer, and they'd be upset because they thought they had until 5 o'clock on Tuesday to get their offer in. But you have to remember, there was no contract, there was no agreement between the buyers and the seller that the seller would not accept an offer up until that time frame, right? There was no consideration given by the buyer to that seller to not accept an offer until 5 o'clock on Tuesday. And so the seller could accept an offer at any time. And so that notification will tell the buyers that the seller's not going to look at anything after a particular date. But again, it doesn't stop the seller from accepting an offer before that date, new or existing offer. Option number 4 is reject all offers. So in the event that the seller doesn't wish to accept any of the offers or counter any of the offers, they just simply wish to reject all of the offers, they may do so by marking the rejection box on page 17 of the purchase agreement. It is not necessary to initial each page of the offer in the event that the seller is rejecting. We've made some changes to the time off market information sheet form 2104A. And originally, when we started to make changes to this form, it was specifically to address the fact that we had a dollar amount in there, or a range at least, for the TOM fee. And given what's happened in the market again over the last 12 to 18 months, we realized that we really shouldn't be putting restrictions or suggesting dollar amounts for the TOM fee, because it ultimately is dictated by the market and what the seller wishes to receive as a TOM fee and what the buyer is willing to pay should be completely negotiable between the parties. And so we originally made these changes, or started to make changes to this form based on that one particular issue, but in looking at the form as a whole, we found some other changes that needed to be made. As you all will recall, when we created the TOM fee, it was in an attempt to try to mitigate earnest money disputes that most of the time, most commonly occur over inspections. So buyers typically are terminating over inspections, and as we know, the buyer is entitled to the entirety of the earnest money back in their pocket in the event that they should do so and do so timely. However, there were a lot of disputes over earnest money, even if the buyer terminated timely during the inspection phase. And no matter how clear we make the language in the contract, we cannot force the title companies to release the funds. They will only do so if they have a signed agreement between the parties, or perhaps if they have a judgment from a court if the issue is adjudicated. So that's why we created the TOM fee, but we revised this form to address the scenario where perhaps the TOM fee takes you past the inspection phase. It may take you through other contingencies as well. It may go all the way to closing, for that matter. So the earnest money is not required to create a contract between the buyer and the seller. So in the event that instead the parties just decided to provide TOM fee instead of earnest money, that's feasible. I think, again, more likely it's going to be used after the parties get through the inspection phase. But again, there's nothing that says it can't be used for other contingencies or further along in the contract. So we've modified the TOM fee information sheet to reflect that. We've taken out reference to the TOM fee inspections that we had before, and have just left it open. Because again, the parties can negotiate exactly how far along in the contract this TOM fee is going to get the buyer before they have to deposit earnest money. And like I said, they might ultimately decide they never have to deposit earnest money. So the first section talks about what is a TOM fee. It also defines what it means to be off the market. A lot of questions have come up about sellers who continue to actively market the property for sale even though the buyer has paid a TOM fee. You'll notice that we don't address marketing of the property in the definition of off the market. We simply say that it means that the seller cannot accept any other offers to sell the property unless those offers are backup contracts. So we don't address the marketing component of it. We do note, however, that if the buyer has entered into a buyer sale contingency and they have used 2503, NMAR form 2503, that the seller is permitted to continue marketing the property and to accept other offers. Now, of course, those other offers are contingent. They're contingent on the first offer falling apart, and that first buyer will be given a certain amount of time as provided in the buyer sale contingency, usually 48 hours or 72 hours to satisfy or waive the contingency. And if they can't do it, then the seller can move on and take that second offer. So we make note of the fact that the TOM fee might not be a good idea if you're using a buyer sale contingency form 2503, because again, that does allow continued marketing of the property and does allow the seller to kind of kick the first buyer out of the contract in the event that the buyer can't satisfy it or waive the contingency within the time frame provided in the buyer sale contingency. We then go on to say, is the TOM fee required? And the answer to that, of course, is no. Completely negotiable between the parties. Is the property off the market if buyer does not pay a TOM fee? And we say yes, it certainly is off the market in the sense that the seller cannot do anything but accept backup contracts. And is the TOM fee credited towards purchase price at closing? And we say no, it's not set up that way in the purchase agreement, but it can be agreed to by the parties that that's the way the TOM fee will be handled. And in that case, if the buyer's offering a TOM fee, then they may put that in an addendum and send it over with the offer. If the seller is requesting the TOM fee, then they might put in the counter offer that they want a TOM fee, but they can also incorporate language that says that that will be credited at closing. And of course, if it doesn't include language that will be credited, the buyer can always come back with another counter offer saying that they want it credited. And then it says if the seller must take the property off the market, even if the buyer does not pay a TOM fee, then why would a buyer offer to pay a TOM fee? Which is a reasonable question. To understand how the TOM fee benefits both parties, the parties must first understand the earnest money process. And so we go on to talk about the deposit and release of earnest money. We explain, like we did in the former version of the TOM fee information sheet, how the earnest money will only be distributed if the title company is presented with an agreement to distribute, and that brokers cannot compel the title company to release earnest money. We then talk about various ways to resolve earnest money disputes. We talk about the ombudsman program, parties engaging in formal mediation, and then ultimately litigation. We talk about interpleaders, and of course that's an action that the title company can file, deposit those earnest money funds with the court, name the buyer and seller in that complaint. The buyer and seller are then forced into litigation, and they must cross-claim against each other to determine who gets the earnest money. The losing party in that litigation will not only pay the prevailing party's attorney fees, because that's what's provided for in the contract, but also have to pay the title company attorney fees for filing the interpleader action. And then if there's no interpleader, there's no agreement, there's no interpleader, the other thing that the title company can do is just hold on to the money for the next 5 years, at which time it becomes it's considered unclaimed property under the Unclaimed Property Act, and it's remitted to the state, and the parties can go deal with it up there. There's still ways to get it back from the state, but it will no longer be with the title company. So you go through all of this, the process of understanding what happens when parties can't agree to earnest money distribution, and it leads you to the benefit of the TOM fee to both parties. So obviously the TOM fee benefit for the buyer is that they're not at the mercy of the seller. And so many times you hear a buyer say, I terminated within the objection phase, but the seller won't sign off, and it's not fair and it's not right because the purchase agreement is clear. Well, again, from a buyer's perspective, you can get through the inspection phase at least, and perhaps other contingencies, without having to deposit the earnest money. Then if they should terminate during that phase, timely terminate, they're not at the mercy of the seller to get their earnest money back. And from a seller's perspective, how many times have you heard, what do you mean? My property's been off the market for 3 weeks and I have not gotten one penny for that, and I have to give back all the earnest money, and that's not fair. Well, again, if the seller had requested a tom fee and really made that a condition of selling their property to the buyer, then they'd have a little money in their pocket. And yes, they have to give back earnest money if it was deposited, but they don't have to give back the tom fee. So there are benefits on both sides of the aisle for the tom fee, and we talk about that in this section. In the last portion of the time off market information sheet, we talk about how much the typical tom fee is. And we used to have a dollar amount in there, but we've taken that out because we've seen over the last 12 to 18 months, the market is dictating tom fees. And we don't want to limit or try to predetermine what those tom fees are going to look like. In some markets, they've been much, much higher because of supply and demand. And as the market evens out a bit, I think we'll see those numbers coming down. But again, that should be completely negotiable between the parties and dictated by the market. We did not change the tom fee considerations and giving the buyer and seller some things to think about when they're setting time fees. And we did not change how the tom fee is paid. So those two sections have remained exactly the same. The next form that we thoroughly revamped is the walkthrough statement, Form 5110. At the top of the form, there is a box with those triangles, which indicates it's an important notice. This says that for purposes of this statement and only this statement, the signature of one buyer on this walkthrough statement binds all buyers on the purchase agreement to the representations made herein. So this is for, again, this statement and only this statement. If only one buyer does a walkthrough or one buyer decides to waive the walkthrough, then it binds all buyers on the purchase agreement. Below that box, we identify the sellers and the buyers and the property. And then the next box is the waiver box. So if the buyers are waiving their right to conduct a pre-closing walkthrough, this is where they do it. They check the box and they sign there. And they're acknowledging they have a right to conduct a pre-closing walkthrough. They're acknowledging that they've been advised to conduct a pre-closing walkthrough, and they are waiving that. They're declining to do it, and they're holding the brokers harmless from anything that they may have discovered, anything the buyers may have discovered during the pre-closing walkthrough that they have decided to waive. Below the waiver box, in the event the buyer does conduct a pre-closing walkthrough, we have an identification of the way that they do that and when they do it, the manner and date and time, and whether it was done in person or virtually, and who attended that walkthrough. And then we have two options. We have objection and satisfaction. In the objection box, if they should check that, and it may be because either A, there are things that have changed with the property since the buyer went under contract, other than normal wear and tear, or B, the seller agreed to do certain repairs as part of the ORW process and have failed to complete those repairs. So this is where the buyer gets to set forth what those issues may be. And then there are three options under that section. There is the option for notice to cure, an option for an amendment, and an option for proceed to close. So as you recall, in our revised purchase agreement that released, I think during our last round, which was several months ago or 6 months ago, we introduce this notice to cure into the deadline default. So in the event that there's a deadline default in the contract, the non-defaulting party has an obligation to notify the defaulting party that they have missed a deadline and to give them a 2-day opportunity to cure. In the event, for example, that a seller was supposed to have, because this is what happens by the walkthrough date, they were supposed to have all of the repairs made that they agreed to do per the ORW, and they have failed to do that by that deadline, by that walkthrough date, then they are in default. And it is a deadline default because there's a deadline by which they were supposed to have those repairs made and they didn't get them made. And so the buyer would have to serve the seller with a notice to cure, a 2-day notice to cure. Well, there's another form for that. But instead of having to go to the other form, this will serve as notice. So the buyer can check the box that says objection, explain what still has to be done, and check the 2-day notice to cure, which then triggers the seller's obligation to get those things done in the next 2 days, or there will be a default that the buyer can then decide if they don't want to go to closing, if they want to sue for specific performance, whatever they want to end up doing as a result of that default. Alternatively, the parties can enter into an amendment. So if they've done, they haven't had chance to do all the repairs and they want to extend the walkthrough date to have another walkthrough so that the buyer can come back in and check for the repairs, which also may require that there be an amendment that extends the closing date, because often walkthroughs are a couple days before closing. So if the buyer needs, longer than 2 days to get things done, then you may have to extend that closing date to give the seller that opportunity. And in that case, an amendment would have to be created. And on that amendment, it would talk about a new date to have all of those repairs completed. And it would also talk about any closing extensions that would need to be done. And then the last one is proceed to close. So in the event that the buyer has to close, whether it be loan lock issues or because they have to get out of the place where they're staying and they need a place to go, or whatever the case may be, and they want to proceed to closing, but the seller has promised to do things that the seller hasn't done, and that's going to cause the buyer financial damage, the buyer can opt to go to closing, but they can maintain their rights to pursue damages against the seller after closing. And that's what the proceed to close is. And then the last box on the page is satisfaction. And this is where the buyer acknowledges the property is in the same condition as of date of acceptance, reasonable wear and tear accepted, and that all agreed upon repairs and improvements have been completed. And so they're completely satisfied, and they sign that box number 3. The next form that we've made changes to is Form 2106, which is the Tenant Occupied Property Addendum. Now, interestingly, this form has been in the library for a very long time, but it has not been referenced in the purchase agreement anywhere, and so I don't think many people have been using it, which is a shame because it's a terrific form. And when I realized that brokers weren't using it and why they weren't using it, we amended the purchase agreement to incorporate 2106 into the purchase agreement. We'll talk about that in a minute. And then I also revamped this Tenant Occupied Property Addendum a little bit. So let's walk through this form. The Tenant Occupied Property Addendum would be used if a tenant was going to be remaining in the property after closing. So in the event the tenant's going to vacate the property before the buyer closes, then this is not a necessary form. But in the event the tenant is going to remain in the property, then this is a form that the buyer would want completed, because it requires the seller to provide the buyer with all of the rental lease agreements, all amendments to those. It requires the seller to reduce to writing any oral agreements that they may have with the tenants, and to provide anything that is part of the rental package, which we define as things such as personal guarantees, the exercise or waiver of an option, settlement agreements regarding disputes under the rental agreement, changes of address notice, any material correspondence between the seller and the tenant, lead-based paint addenda, prior estoppel certificates, any complaints that the tenant has made, etc. So this is the rental package that must be provided to the buyer. Current estoppel certificates are also provided for in here. So it's requiring the seller, if the buyer completes this as will complete estoppel or provide estoppel certificates, it requires the seller to provide estoppel certificates for a percentage of the tenants. And if it's a multi-tenant complex, then perhaps the buyer only wants them for a handful of them, half of them, or what have you. If it's just a single tenant occupancy, then they probably want it for that particular tenant. But the tenant estoppel certificate is a great form, because what it does is it gives the buyer some information about the tenancy from the tenant's perspective. So it's asking the tenant, is this the right rental agreement that's in full force effect? Were there oral agreements between you and the owner? Are there problems happening with the property? So you get the tenant's perspective on all that if the buyer has requested estoppel certificates. The other really important factor on this is paragraph 5, and it says that the seller warrants the rental agreements are in full force in effect and have not been amended except as provided by attachments that have been included as part of the rental agreement. And it goes on in paragraph 7 to say that there will be no enlargement of the lease term, no increase or no decrease in the rent, no return of any portion of the security deposit, and no material change, modification, or amendment of the lease as reflected in the exhibits to the addendum without the prior express written consent of buyer. Had a call on the hotline from a buyer not long ago. He had bought a multi-tenant complex, and there was a month-to-month tenancy with each of them, and they were paying far under fair market value for the units. And so the buyer's plan was to go in, give them 30 days notice that the rent would be increasing, and to increase the rent to fair market value. Right before closing, the seller entered into long-term lease agreements with all of the tenants, a year lease agreement with each of them, and it locked in that rate that they were paying prior to closing, that lower rate. So obviously I referenced the tenant occupied property addendum, but the buyer had not used it, so they didn't have the benefit of this language, which again is very important. It also addresses whether or not there are any defaults in the rental agreements, and then how the security deposits and prepaids will be handled at closing. They're going to be credited. So really important form if you have a situation where a tenant is going to remain in the property after closing. We've made some very minor changes to the listing agreement form 1106 dealing with compensation. The changes we made to 1106 are in paragraph 11A, specifically the co-op broker commission. So it used to say, or currently says until the new form is out, that you're going to enter into that section the percentage of the total sales commission that you're willing to share with the co-op broker. So, for example, in the event that you were willing to share your commission 50-50 with a co-op broker commission, you'd simply put in there 50%. Easy enough, right? But in the event that it wasn't 50%, let's say it was some other percentage of the total commission that you were receiving, then those calculations weren't as easy to do. I mean, for example, and for example only, let's say that you were charging 5% commission and you were going to share that, you were going to keep 3 and give 2%. You'd have to calculate what 2% was, what percentage 2% was of the total commission of 5%. And again, that might not come naturally and be intuitive. So what we changed it to say is what commission as part of the total sale is going to go to the buyer's broker. So that's easier, right? Because in a scenario, for example only, that you were charging 6% to the seller and you were going to keep 4 and you were going to give the other 2% to the co-op broker, then 2% would go in there because it's not 2% of the amount that you're receiving, it's 2% of the sales price of the property. So we amended that accordingly. I think that's easier to complete, and I think probably a lot of brokers were completing it like that anyway. But I'd like to point out one more thing before we move on from the listing agreement. It's paragraph 11B. It's not on the screen, but it's a section that entitles brokers to commission in the event of an other event. And we define what those other events are. And they're things like you bring a ready, willing, and able buyer willing to pay full list price on the terms that the seller originally said that they would accept, and the seller refuses to contract, or the seller decides they don't want to sell their house anymore and they want to take it off the market, or they make it unmarketable in some way, or they enter into a contract and then they breach the contract and don't perform. So this is the paragraph that says that in those events, you still get some compensation, but it is a separate section than section A, sale, for several reasons. First of all, in the event of sale, if you've offered a co-op broker commission, you're going to have to pay that co-op broker commission, right? So you may have set a number in that compensation paragraph A for sale that enables you to do that, right? A higher number that enables you to share that commission with another broker. However, if those other events occur, there's no sale that occurs and therefore no obligation to share a commission with a co-op broker. Number 2, of course, you don't have the exposure. You don't have the same liability if there's no sale because you're not going through a whole transaction with your seller. So that may factor in to the amount that you would charge. And of course, you don't have the work, right? Because this is a situation where the seller is refusing to sell. So you don't have the work involved in getting that transaction to closing. So all of those things come into play, and you may be willing to accept something less than the full commission that you would be charging in the event there was a sale. You may be willing to accept something less than that. And, a lot of people think, well, in the event that they breach the contract in some way, I should just be entitled to all the damages that I would normally be entitled to under the contract, my full commission. But those are speculative. I know we've had a really hot market lately, but in other markets, perhaps it's not a guarantee that seller's property is going to sell during that period of time that you have the listing. So these are basically liquidated damages in that other section that's going to compensate you in the event that one of those other events should occur. But please don't forget to fill it out, because I get calls from brokers on a regular basis where a seller has decided they don't want to sell their property anymore, and there's no provision in there. There's no amount in there that the parties have agreed to in the event that the seller decides to take their property off the market. And so arguably there's no commission due in that scenario, again, if paragraph 11B has not been completed. We've made changes to the occupancy agreements, both the buyer's occupancy agreement and the seller's occupancy agreement. Those are forms 2201 and 2202. Let's start with form 2201, which is the buyer occupancy agreement. We've added a big box at the top of the agreement, and it alerts the buyers and sellers to several things. First of all, it advises them not to use this form for occupancies that are really going to be greater than 7 days. And 7 days is kind of an arbitrary number that we came up with. And it simply was a balance between, in the event that there's a few days, up to 7 days, that the buyer may need to move in early, we don't necessarily want to burden the buyer and seller with having to get some comprehensive agreement in place. But at the same time, the longer the occupancy, and we've kind of decided that's more than 7 days, the greater the chance that there will be issues that arise that this form does not address. Because this form, as you notice, is a very short form. It's a 2-page form. So if a buyer was to move into the property before closing, long before closing, there could be all sorts of issues that this form just is inadequate. It just doesn't address those issues. I mean, we could be getting into, improvement to the property, or property taxes, who's going to take care of those, and just various issues that could arise that, again, this form is not intended to address. And normally, a landlord-tenant situation would be governed by the Uniform Owner-Resident Relations Act, but there's an exception in the Act for buyers that move into properties prior to closing. So where you could normally rely on the Act to fill in the gaps from this occupancy agreement, you can't necessarily rely on the Act to do so in a buyer occupancy situation because of the exemption in the Act for buyers who move into properties before closing. So we advise the buyer and seller in this situation, if it's going to be a longer term tenancy, more than 7 days, to have an attorney draft a more comprehensive agreement that addresses other issues, many other issues that could arise if the buyer is moving in long periods of time before closing, right? Something more than 7 days, we say, is a long period of time before closing. So that's the warning you'll find on the first page. The other change that we made to Form 2201 is in paragraph 6C, which deals with the maintenance of the property. And it used to say that seller is responsible for maintaining, because it was still the seller's property. However, now we have the option of seller or buyer is responsible for maintaining the property, heating, cooling, etc., from date of possession to the closing date. At the top of the seller occupancy agreement, Form 2202, we've also added a box. And again, we have advised that this form not be used for anything longer than 7-day occupancies, because it doesn't address many issues. Again, it's a 2-page form, and it's not intended for long-term tenancies of any sort, occupancies of any sort. So the difference between the buyer and the seller occupancy agreement is that the buyer and seller relationship in a seller holdover situation is governed by the New Mexico Owner-Resident Relations Act. So everywhere that this occupancy agreement is deficient or fails to address something, the Act would step in and fill in those gaps. But we do tell the parties that if the seller is going to occupy longer than 7 days, that they should use a different form. And they can use the New Mexico Residential Rental Agreement, because that form very much incorporates the Owner-Resident Relations Act. On the back of that form, there is a space to identify who will be managing the property. So the broker can identify that the owner, the buyer of the property, will be managing the property, and that the broker will not be serving in any way, shape, or form as a property manager. So the broker can provide the form and assist them even in filling out the form, but then identify that they are not going to be managing the property. And it doesn't make you a property manager, the fact that you helped them complete that form, if you're not indeed going to be managing the property and you don't have a management agreement. So also in the box, there is a link to visit the New Mexico Real Estate Commission's website, or to request a copy of the Owner-Resident Relations Act from your realtor, because the Act, which is available on the website, will explain to the buyer and seller all of the law that will govern that relationship between the two of them. So it's important that they understand what that law is. So again, they can either go to the Real Estate Commission's website, and there's a link there, or they may ask you to complete or to provide them with a copy of that. And in the event that they want you to do that, you can get that Owner-Resident Relations Act from the New Mexico Real Estate Commission's website at that link, or if you just do a search of the website under the rules and laws, it's the second PDF that pops up under the rules and laws, a complete copy of the Owner-Resident Relations Act. We have made a minor revision to the Objections Resolution and Waiver Form 5109. We have amended Section 3 of the ORW to track the language in the purchase agreement and then expanded on it ever so slightly. So as you recall, a couple of years ago, we changed the purchase agreement to address how buyers would be handling inspection reports when they made objections. And we said that if they are objecting to an item on a document or survey, then they're going to produce the entirety of that document or survey with their objections. If they're objecting to an item on an inspection report, they're only going to produce the section of the report on which their objection is based. And I've talked about that in great detail in the past, about the copyright issues and the reason for making these changes. We say that the buyer shall not send the entire inspection report unless requested in writing. The addition to this particular bullet that, again, you'll see in the purchase agreement is we say that not only can the buyer include or copy or however they want to relay that section of the report on which their objection is based, they can also incorporate it into this Section 3 of the ORW if they prefer. We also say in paragraph 3 here that once the buyer makes objections, the buyer may not withdraw his objections for the purpose of terminating the agreement. And again, we emphasize for the purpose of terminating because bullet number 4 says that notwithstanding the foregoing, at any point in the resolution deadline, before the resolution deadline, the buyer may withdraw his objections for purposes of taking the property as is. So once the buyer makes their objections, they can't withdraw those and say, I terminate, right? They had a right to terminate by the objection deadline, but once they make those objections, they have to give the seller an opportunity to respond to those. But we say that at any point prior to the resolution deadline, the buyer may pull all of the objections off the table and take the property as is. We made some changes to the real estate contract addendum, and those changes, exact changes, will be carried through to the real estate contract itself. We have removed the paragraph below paragraph number 1, and that paragraph simply explained why there were quote-unquote missing paragraph numbers in the real estate contract addendum. The addendum was numbered to line up with the real estate contract numbers, and so there were additional paragraphs in the real estate contract that were omitted from the real estate contract addendum because they were not negotiable terms. And so we didn't include those paragraphs in the addendum, but we did try to maintain the same numbering. And so you'd see certain numbers that were actually skipped or omitted from the addendum. It caused a lot of confusion. And those who are drafting real estate contracts aren't typically using our real estate contract addendum, the NMAR form. So the fact that the numbers in the addendum and the numbers in the real estate contract do not line up exactly is really of little import. Throughout this document, we have taken out initials and added check boxes. We found that the initial spaces were not being used properly anywhere, so we substitute them simply for check boxes. We made some changes to paragraph 6, which is the buyer to maintain insurance paragraph. The first change is in 6A2 where it says liability insurance. It used to say public liability insurance, which gave the impression it only applied to commercial properties. But liability insurance covers situations where somebody should come onto the property and get injured, and that could happen in a residential context as well as a commercial context. So we removed the term public. We also added a provision for flood insurance in the event that the property is located in a flood zone. So at the top of paragraph 6, it says check applicable. So in the event that liability insurance and or flood insurance is going to be required, the parties have negotiated that, then those boxes would be checked. In paragraph 6B and C and D, it talks about the type of insurance that would apply to various scenarios. So first is 6B, and it talks about if there are no prior obligations. So there's no assumed obligations, there's no wrapped obligations, and in that event, the buyer shall maintain insurance in accordance with paragraph 6A above, with an insurance company satisfactory to the seller, and such insurance shall be maintained for the benefit of buyer and seller as their interest may appear. And buyer shall furnish a copy of the insurance policy or certificate of the insurance policy to the seller annually before the expiration of the existing insurance, stating that the coverage shall not be canceled or diminished without a minimum of 15 days prior written notice to the seller. Then paragraph 6C talks about if the buyer is assuming a prior obligation. And when we talk about assuming a prior obligation, remember we're talking about a buyer stepping into the shoes of the seller. So that third-party lender who has that prior obligation now views the buyer as the borrower, and the seller is no longer obligated. And there are not a lot of assumable loans out there anymore. So this isn't going to come up very often. But in the event that there is an assumable loan and the buyer is assuming that prior obligation, then the buyer shall maintain insurance as required by the holder of the assumed obligation. And then paragraph 6D deals with a scenario of wrapping the prior obligation. And that is what most commonly happens when there is an underlying mortgage and somebody sells a property on a real estate contract, is they wrap the underlying mortgage, meaning that the seller is still responsible for the underlying mortgage, but the buyer is making payments on the contract, the real estate contract, that are then also being applied to the payment on the underlying obligation. So in the event that the buyer is wrapping the prior obligation, the buyer shall maintain insurance as required by the holder of the underlying obligation, because the underlying obligation, the mortgage holder, will have requirements. And then in addition to that, and this is very important, in addition to that, the buyer shall maintain insurance in accordance with paragraph 6A with an insurance company satisfactory to seller. So I know this sounds a bit counterintuitive that you would have two insurance policies on a wrap situation, but in the situation of a wrap, you want to maintain the underlying insurance just as it is, because the underlying mortgage holder is watching that insurance policy, and they don't want to see changes in that policy. If the policy gets dropped, then they can either foreclose on the property or they can force insurance at a premium. And so you want to maintain that insurance policy for the purposes of not creating any issues with the underlying mortgage holder. But in the event that there should be a claim, whether it be loss of improvements or liability issues, and the buyer should try to make a claim against that policy, that policy is maintained for the benefit of both the mortgage holder, underlying mortgage holder, and the seller, they may claim that policy is not for the benefit of the buyer, and they may deny that claim. And in the event that should occur, then the buyer would have another policy in place for the benefit of both the seller and the buyer, to replace the property in the event of it was an improvement loss or to cover any liability issues. And so that's the additional policy that the buyer would be obtaining for that purpose. And paragraph 6D3 says that all insurance required under this paragraph 6D shall be maintained for the benefit of the buyer and the seller, again, as their interest may appear. And again, the seller shall furnish a copy of the insurance policies or certificate to the seller annually before expiration, and that the seller will be given at least 15 days prior written notice before any buyer insurance is either canceled or diminished. So paragraph 8 has been revised considerably, and it deals with the payment of insurance and taxes. In paragraph 6, we establish how much insurance has to be paid. And then in paragraph 7, we say that the buyer is responsible for paying the property taxes. In paragraph 8, we talk about how those will be paid. And there are several options. Paragraph 8A talks about a new escrow or impound account. So if there's no prior obligations, or the holder of the prior obligations has not already established an impound account, then 8A is what you'll check. And this means that if the buyer is making property tax payments every month or insurance payments every month, that those premiums will be held by the escrow company in this newly established escrow account until such time as they need to be remitted to the assessor or to the insurance company. So they're going to establish a new account for that purpose. 8B is in the event that there is an existing escrow or impound account already established by the underlying obligation. So whether it be a mortgage or a real estate contract, they've already established an underlying impound account where they're holding property taxes or insurance or both. And so in the event that there's already one established, then obviously the escrow company doesn't have to do that. But we're saying in 8B, what is going to be held in that account? Is it going to be taxes, or is it going to be insurance, or is it going to be both? So you're going to mark the boxes accordingly. And then in addition, there is an option to establish a new account for that additional insurance policy that we talked about in the last slide. So in the event that there is an underlying mortgage and you have an insurance policy associated with that, and you're maintaining that insurance policy in accordance with the mortgage requirements, and as we talked about, now you're going to establish another insurance policy to protect the buyer and the seller in the event that the first one fails. Is the buyer going to be making payments monthly towards that insurance policy? And if so, there needs to be a new account established by the escrow company to hold those payments and send them in. So there's an existing account for the existing property taxes and maybe insurance payments, and then there's a new one being established for this second policy in the event that it's running through escrow as well. And then the last option here is option C, which is direct payment of property taxes and insurance. So in the event that the buyer is actually going to be paying these things directly to the insurance company, to the assessor's office, and it's not going to run through escrow, then paragraph 8C would be selected. Paragraph 9 is a new paragraph, and it deals with homeowner or condominium association fees. And paragraph A talks about how they're going to be paid, whether they're going to be paid directly to the homeowners association or condo association, or whether or not the buyer is going to pay them to the escrow agent. And if they're paid quarterly or yearly, unless otherwise indicated, the amount to be divided between the number of payments made to the escrow agent. So in other words, they'll be prorated each month, and they'll be held in the impound account and then remitted to the association when they're due. And then obviously paragraph 9B is the current dues. How often those dues are to be paid are indicated in paragraph 9C, and then the contact information for the homeowner or condo owner association is in paragraph 9D. The default paragraph has been modified slightly. We had in there cure for default 30 days, but there was really no explanation of what that meant. So we explained it a little bit more in the addendum that the cure to default means that once the buyer has defaulted and the seller generates a default letter, this is the period of time that the buyer has to cure the default before the seller can exercise their options under the contract to either A, take the property back or bring suit for final payment on the real estate contract. So because we had 30 days in there, I think everybody thought that that 30-day period was dictated by law, but it's not. There is case law that stands for the proposition that anything less than 30 will be highly scrutinized. So if a seller attempts to take a property back without giving a buyer at least 30 days notice to cure the default, that could be problematic. But as anything over 30 days is completely allowed and negotiable between the parties. So we have now made that clear that it shouldn't be anything less than 30 days, but it could be something more than 30 days. The default of the default period will still be 30 days in the event that nothing else is completed, but in the event that the parties want to extend that 30-day period, give the buyer longer period of time to cure a default, then this is where they would elect for a longer period of time. And then we solicit the buyer's address because this is the address to which the default notice will be sent. We do have the buyer's address in other places, but if there's a different address for that default notice to be sent, this is where we want to know what that is. So there's a space for that. And then a new section for the county clerk filing because we want to put the world on notice that the seller has sold the property. And so something is filed of record, and that can either be the contract itself or it can be a memorandum of real estate contract. So which doesn't have all of the entire contract, doesn't give all of the terms of the contract in the memorandum, but it does put, again, the world on notice that the seller has sold the property on a real estate contract. And this, of course, is for the protection of the buyer so that the seller can't resell the property without notice to another party that it's already been sold on a real estate contract. So all of the changes that we made to the real estate contract addendum will be incorporated into the real estate contract form 2401. And just a reminder as to that process. So you as brokers are going to complete the purchase agreement, and then you are going to add the real estate contract addendum to that purchase agreement. And then when you take that to the title company will make arrangements to have that real estate contract drafted. Alternatively, the parties can elect an attorney themselves to do so, but more typically than not, the title company is hiring the attorney to draft the form when you take the purchase agreement with the real estate contract addendum to the title company. We've made a very small change to the HOA disclosure certificate, form 4700. As you recall in the purchase agreement, there's a date in the grid by which the seller must deliver the HOA disclosure certificate, and then a certain amount of time for the buyer to object to anything therein. In this provision of the disclosure certificate, we say that the date that the buyer has to object is no less than 7 days, but in the event that the parties have agreed to some longer period of time in the grid, something more than 7 days, then the buyer would have that longer period of time per the contract to object to any item in the disclosure certificate. So no less than 7 days, but it could be more than 7 days depending on how much time was given in the purchase agreement for objection to the HOA disclosure certificate. We've made a few small changes to the earnest money distribution form 5105B. The first thing you'll notice on this form is that there are 3 boxes. An extra box has been added. And the box at the top has the parties agreeing to how the earnest money will be distributed between the buyer, seller, brokers. And then the box beneath that is talking about deductions from the earnest money, but there are a couple of things you have to keep in mind. You can only list below those expenses that are to be deducted from the earnest money and paid by the title company from the earnest money. And expenses can only be deducted from the earnest money if the party responsible for paying the expense is receiving the earnest money. If the party is responsible for an expense, but the earnest money to be received by the party is insufficient to cover the expense, the title company is authorized to send the funds available to the service providers in the order listed until such funds are exhausted. So what does this mean? It means that if the buyer is supposed to get 100% of the earnest money back, but the seller has an outstanding invoice that they're supposed to pay, that would not be listed here because 100% of the earnest money is going to go back to the buyer, and the title company will have no additional funds to pay any seller expenses. So it wouldn't be listed. So again, you're only listing expenses that are going to come out of the earnest money, right? And in the event that the party receiving the earnest money is responsible for paying an expense, and it's going to be listed here, then if there are multiple expenses, then you're going to list them in the order that they should be paid. So you're going to put the first expense to be paid on line 1, and the second and the third and the fourth. So if there are insufficient funds to pay everything that the party receiving the earnest money is supposed to pay, then the title company will have some direction as to what order those have to be paid. And they will pay them until the funds are exhausted. And after you've calculated the deductions, then you will figure out the remainder of the earnest money and then decide how the remainder will be dispersed to the buyer, seller, or the brokers. And then the interpleader action information is below that, as it has always been. A couple small changes to the termination agreement form 5105. We've made an addition to the name of the form underneath termination agreement, in parentheses, waiver of specific performance. That's what this form has always done. It is waiving the buyer's right to make the seller sell and waiving the seller's right to make the buyer buy. And this is a great import to the title companies. They like to know that there's not going to be any claim of specific performance. And so this is what this form does. It's always done this. In the explanation of the form or the effect of the form, it explains what the form does. And it's a waiver of specific performance, but again, it wasn't reflected in the title until now. We made a change to the reason for termination grid. This deals with the various contingencies in the purchase agreement. And the first section is inspections, but also as part of the inspections, as we say in the purchase agreement, the buyer may terminate based on their own investigation or observation. So again, it may not be an inspector that comes in and gives and conducts an inspection that forms the basis of the buyer's decision to terminate, but rather the buyer's investigation or observation. So we've added that, again, just simply tracking with the language in the purchase agreement. We have made some changes to the residential purchase agreement form 2104. We made some changes to the transaction coordinator box at the bottom of the page. The Real Estate Commission, during their last rule change, decided that if you're using the term transaction coordinator, it means you have a license. And so it doesn't mean that everybody who is doing TC type work has to have a license. If you weren't doing things that required a license and that hasn't changed, you still don't have to have a license. What they have done is say that if you're holding yourself out as a TC, then you have to have a license because that identifies you as a real estate broker when you call yourself a TC. So you may be an unlicensed assistant and be doing some things that don't require a license. But if you are saying you're a TC, it means you are a licensed broker. As a licensed broker, you owe broker duties. And so we just clean this up to reflect the latest commission regulations that say transaction coordinators are licensed brokers and they owe broker duties. And then we go on to say that if you're a TC who needs to make any of the disclosures required by broker duties, then you can use Form 2100 to do that. We have moved the index to the back of the purchase agreement because that's where indices belong. We have made a significant change to paragraph 7, which is the cash loan or seller financing paragraph. As you recall, there were some provisions in this paragraph that talked about the buyer's obligations to inform the seller if the buyer should change lenders or change loan programs, or loan conditions should change that would negatively impact the seller. We were also thinking about adding some language to that, dealing with a scenario that has been commonplace as of late, where the buyer says they're going to pay cash and once under contract changes to a loan. And as we were analyzing these various provisions of this section, we thought, why not create instead a catch-all that addresses all of these scenarios? So we eliminated a couple of the paragraphs dealing with changes in loan program and dealing with changes in loan conditions or lenders, and we added this box at the top of the paragraph that says that buyers shall not change the means of payment, cash, loan, or seller financing, the lender or loan program type reflected in the pre-qual letter without seller's approval. And because we had some concerns that the seller may unreasonably withhold that approval if they have a better backup offer, for example, we did put language in there that says the seller's approval shall not be unreasonably withheld. So the seller better have a really good reason for not approving the change. And upon seller's approval, the party shall execute an amendment to this agreement that sets forth the changes and addresses the disposition of earnest money should the buyer not be able to close as a result of the change in payment type and or loan program. And if the earnest money disposition is not addressed in the amendment, then the disposition of earnest money as set forth herein shall apply. So in the loan paragraph, for example, we address what's going to happen to the earnest money in the event that the buyer isn't able to close. And then it goes on to say if the seller does not approve of the change, the earnest money shall or shall not be refunded to buyer. So this section here takes the place now of those sections that dealt with changing lenders, changing loan programs, changing loan conditions, those type things. And it eliminated those paragraphs. We also made a change to subsection B of paragraph 7 dealing with the pre-qual letter, and we have included the requirement that the loan type as set forth in paragraph 7B be identified in the pre-qualification letter. Now, I will say that we have gotten some comments about the ability of a buyer to get a pre-qual letter that specifically includes these elements. But as we've discussed at the Forms Committee on a number of occasions, if the buyer makes it clear to their lender that they need a pre-qual letter that meets these qualifications, then they can get a letter that meets these qualifications. And if they can't get it, they should be determining that before they write their offer so that they can include an amendment with their offer that says that the buyer will submit a pre-qual letter that stipulates the following, and that will take precedence or supersede this paragraph B2. So again, the idea here is that they will meet the criteria set forth in this section, that they can, as long as they articulate the need for a letter that meets the criteria when they're dealing with their lender and trying to get that pre-qual letter. But if they already have been dealing with their lender and know they can't get a pre-qual letter that meets this criteria, then they should be attaching an amendment, addendum amendment to their offer saying we will produce a pre-qual letter that stipulates the following, and it will include whatever their lender has said that they can provide. We have modified paragraph 9C. 9 is the appraisal paragraph, and C is if the appraised value is less than the purchase price. We have significantly amended this to simplify the process. So we used to have different time frames for whether or not the buyer wanted to exercise their right to buy even though the appraisal came in low, or whether or not the parties were renegotiating a price. So we have created consistency with the time frame in this section and said that the magic number is 5 days. The other thing that we have done is we have made it clear that the buyer shall deliver a copy of the appraisal to the seller. So in the event the appraised value is less than the purchase price, the buyer shall deliver a copy of the appraisal to the seller, and then the buyer shall have 5 days to do one of three things. Notify the seller in writing of buyer's election to proceed with the agreement without regard to the amount of the appraised valuation, or B, negotiate a revised purchase price with the seller, which revised purchase price shall be incorporated into an amendment to the agreement and fully executed by the parties. So within that 5-day period, the parties have to renegotiate a price, agree to that price, create an amendment, and fully execute that amendment within that 5-day period. And the last thing they can do is the buyer can notify the seller in writing of the buyer's intent to terminate the agreement. Now, if the buyer fails to satisfy one of the options within that 5-day period, which such satisfaction to include, if applicable, the parties fully executing a price modification amendment to the agreement, then the agreement shall automatically terminate and the earnest money, if delivered, shall be refunded to the buyer. So again, we've simplified this to say 5 days. The parties are either buyer is either going to notify seller they want the property, notify seller they don't want the property, or the parties are going to renegotiate a price and they are going to memorialize that in an amendment to the contract and fully execute it within that 5 days. Or again, if that doesn't happen, the contract is going to automatically terminate and the earnest money is going to go back to the buyer. In paragraph 14, the prorations paragraph, we have reworded it slightly to create a clear affirmative obligation on the part of the seller to provide the buyer with property-specific fees, lease agreements, private memberships, association fees, taxes, contract service agreements, etc. So there's an affirmative obligation that the seller will provide all of these things. We've added 2 new fees to the cost to be paid grid, paragraph 15. One is the document processing fee, and that's under title company closing cost. A number of title companies have started charging this fee over the last 3 or 4 weeks. In the event that your title company doesn't charge it, then it won't matter who has elected to pay it. But in the event that your title company does charge it, of course, it's important to know who's responsible, because right now the title company is assessing it on one side or the other, but there's no provision in the contract for who's responsible for paying it. And then we moved a fee that was in paragraph 9B into the grid, and that's the appraisal for cash or seller financing. So it's not a new fee. Obviously, if the parties have elected to do an appraisal, then that appraisal fee is covered or was covered in 9B. But it's not often that you're looking at other sections of the contract to determine costs. And so we've moved that out of 9B into the cost to be paid grid so that all the costs are in one place. Paragraph 16 is the FERPTA paragraph. And we slightly rearranged the paragraph to clarify what the exception is and whether or not the exception applies. So remember that the exception is that the sales price of the property is no more than $300,000 and the buyer will be using the property as a primary residence. Then we have the buyer warranting that the exception, as we just stated, applies or that it does not apply. I will add with FERPTA, a number of years ago when they came up with the QSS, the qualified substitute, we worked with the title companies around the state to get them on board to providing that service. And since that time, I'm afraid the wheels have come off the bus a bit in that regard, because I'm hearing from brokers around the state that the title companies are not participating or not willing to participate in serving as the QSS and then providing that statement at closing. And we're going to have to reach out as an association again and trying to get that back on track. In the meantime, buyers brokers, please be aware that your buyer needs to have a QSS when they walk away from that closing table. And the only way that the title company can provide the buyer with a QSS is if the seller has provided a non-foreign seller affidavit to the title company. And unfortunately, because we've kind of gotten off track with this and the title companies are not just doing this routinely, it is going to be incumbent, or the onus is going to be on the buyer and the buyer broker to make sure that they get that information at closing. The contract, paragraph 16 here, does provide that in the event that they don't have the QSS at closing, that they have the right to withhold funds from the seller's proceeds to remit to the IRS, because you have to recall with FERPTA, in the event that the seller is a foreign person, the buyer is obligated under the law to retain funds from the closing and remit that to the IRS. So it's imperative that we determine whether or not they are or are not a foreign person. And the way we determine they're not a foreign person is they provide the non-foreign seller affidavit to the title company, and then the title company provides a QSS to the buyer. Now, the non-foreign seller affidavit that the seller provides to the title company is filled out in its entirety. So if you as a buyer's broker are getting a non-foreign seller affidavit provided that has no social security number on it, then that does no good. That piece of paper is completely worthless. It must be completed by the non-foreign seller in its entirety and then provided to either the buyer or to the title company. Of course, there are problems with it being provided to the buyer because the seller is unlikely to feel comfortable providing social security information to a buyer that they don't know. So it only makes sense that they would provide it to the title company, and that the title company would then turn around and provide a QSS to the buyer at closing. But again, we're getting some resistance. Some of the title companies are not cooperating. The buyer's brokers really need to be pushing back and trying to get that done. We are going to have to revisit that issue as an association and work with the Land and Title Association again to see if we can get that whole thing back on track. Paragraph 19G has been modified to reference the tenant occupied property addendum. I talked about that earlier in the presentation. So in the event that you're going to have a tenant that's going to remain after the funding date, after closing, then you would check this box. And if it's checked, then the tenant occupied property addendum would be attached. And the estoppel certificates are no longer referenced in this section because they're referenced in the tenant occupied property addendum. So it goes on to say that if this box is not checked, then the seller warrants that the tenant of the property, if any, shall vacate the property by the funding date. In paragraph 19, we have made some changes to paragraph 19I, which is the grid that sets forth various documents, the delivery, objection, and resolution dates for those documents. We made a few changes there. To NMAR Form 1110, which is on the first line, we have included the term adverse material facts because our property disclosure statement is now called an adverse material facts property disclosure statement. We have replaced reference to the estoppel certificates with language talking about the accompanying documents to NMAR Form 2106, the tenant occupied property addendum, because the estoppel certificates are some of the documents that will be provided under that form, but there are a lot of other documents as well. So all of those documents are included in the new language accompanying documents to NMAR Form 2106. And then towards the bottom, we've added a field for documents that have to be disclosed per paragraph 14, the prorations paragraph. So we talked about in that paragraph how the tenant had an affirmative obligation to disclose security system contracts or propane tank contracts, these kind of things, all of those type service contracts or fees that are associated with the property. And so this would be the deadline for delivery of that information and objection and resolution as well. We made a change to paragraph 22A3, and that's the paragraph that tells the buyer that they need to investigate square footage during the inspection phase. It used to say that they had to investigate not just the square footage of the improvements, but the square footage of the entire real property. So, lot line to lot line. And realistically, that's not when that's happening. So home inspections aren't going to give you that kind of number. The kind of inspections they're doing under this paragraph aren't going to give you that number. That number is going to come out of a survey. So it's not going to come up at the time that they're doing these type of inspections. And so we've taken reference to that out of this paragraph. This is strictly for square footage of improvements. And I will remind everybody that during our last round of changes, we put some language in the appraisal contingency paragraph dealing with square footage, reminding the buyer that the appraisal contingency is not a square footage contingency. So a lot of times the buyers will not investigate square footage during the inspection phase. The first time they're hearing about square footage from some outside source that perhaps they've hired, or some appraiser that the lender has hired, is during the appraisal phase of the contract, which is often way after the inspections, as you know. And they often, if it comes in low, if the square footage comes in low, they want to renegotiate the price, they want to terminate the deal. And so we're reminding them now in that appraisal contingency that it is not a square footage contingency. It does not give them a right to terminate the contract or change the price unilaterally based on the square footage coming in low. and they should be doing all of their investigation of square footage of the improvements during the inspection phase. We've added a new paragraph 48, which is entitled Significance of Initials, and it says that initials signify that the buyer and or seller has reviewed and understands the pages in the section. Initials do not signify acceptance of the terms on the page or in the section. And by their signature here too, the parties represent that they have reviewed, understand, accept, and agree to the terms contained in this agreement. So in other words, initials do not constitute acceptance, just review and understanding.